Hobby Lobby vs. Burwell, a case presented in front of the Supreme Court in 2014, but had started the journey back in 2012 with the Green family, a religious family that owned the corporation Hobby Lobby. The Greens felt that under the Religious Freedom Restoration Act of 1993, they should not have to provide for controversial contraceptives for their female employees that were required under Obama's Affordable Care Act of 2010. The real reason for their unwillingness was that this family believed that by their religion these four contraceptives were akin to abortion. This case could only come up now because of these two conflicting laws: the Religious Freedom Restoration Act, an act recognizing that religion is an unalienable right, and all laws may bend if they interfere with religion too much, so as they do not affect those trying to follow their own religious practices, and the Affordable Care Act, an act put into law by Obama that declares what types of health care companies must provide for their employees, that includes having to provide female employees with 20 different types of contraceptives, including the four mentioned earlier. Hobby Lobby first sued in September 2012 that they should not be forced to provide these four types of abortion to their employees. It was ruled that Hobby Lobby had to provide the contraceptives, so Hobby Lobby lost at first. The Green family decided to appeal for immediate review of the situation, but was denied and had to wait until March 2013 to get their case. Again, the case was ruled against Hobby Lobby, and in October, the Green family appealed for the Supreme Court for a better ruling for them. The Supreme Court actually accepted in November 2013. In March 2014, the Supreme Court listened to the arguments of the lawyers.
Using the federal dictionary definition of a person, not only natural people are included, but also corporations, and forcing the corporation to provide these contraceptives is burdening the family. Not the cost, but the idea of the contraceptives, not the cost that the Green family disagrees with.
When a female employee decides that they want these contraceptives, there's an independent interaction between the employee and her insurance company, so the Green family should have no problem with this exchange.
The Green family obviously feels that every time one of these contraceptives are bought by the female employees, they are indirectly providing for them. While they might not be in the exact exchange at the time of purchasing, yet they are still involved in the whole decision.
Remember that this company is a for-profit company, and therefore the religious beliefs of the CEO of the company should not affect those below him or her.
It is not just what type of company it is, but that the owners have serious religious concerns about providing these contraceptives, and it very strongly breaks these people's religious freedoms every time the government forces this upon them. Also, they are set with a choice to decide to get rid of their healthcare entirely and lose a competitive edge, which is the only option if they are to follow their religion or go against their religion and provide these contraceptives. And it is not fair for government to force people to make these decisions.
After careful deliberation, the judges voted on which side they agreed with, and it came to be a 5-4 decision, with the majority believing that it was unconstitutional to force religious families to provide abortion for their employees.
Under the Religious Freedom Restoration Act, a government action that imposes a substantial burden on religious exercise must serve a compelling government interest, and we assume that the Health and Human Services regulations must satisfy this requirement. But in order for the HHS mandate to be sustained, it must also constitute the least restrictive means of serving that interest, and the mandate plainly fails that test. There are other ways in which Congress or HHS could equally ensure that every woman has cost-free access to the particular contraceptives at issue here, and, indeed, to all FDA-approved contraceptives.
Therefore, the minority believe that the employees should receive these contraceptives even though it is against the religious of the company owners.
With the exemption, the court holds the Religious Freedom Restoration Act demands for employers with religiously grounded objections to use of certain contraceptives extend to employers with religiously grounded objections to blood transfusions, antidepressants, medications derived from pigs, including anesthesia, intravenous fluids, and pills coated with gelatin, and vaccinations.
At the same time that Hobby Lobby was rising to the levels of the appellate courts, a similar case was also occurring: the Conestoga Wood Specialties versus Burwell. This very similar situation where the Hahn family, who were the owners of the company, had a problem with the same four contraceptives, the same four controversial contraceptives that they thought were abortion. This case also rose to the appellate levels of the court until it also got to the Supreme Court, so the Supreme Court decided to take both the cases and just merge them into one, so as to save trouble and have them both affect each other. This case is talked about by Andrew Spiropoulos, director of the Center for the Study of State Constitutional Law and Government at Oklahoma State University School of Law, and many other experts as well. Hobby Lobby versus Burwell? Well, overall, I'm not surprised by the decision by the Supreme Court. What I am most surprised about is that so many people waited with bated breath over this decision. Most cases that have dealt with the Religious Freedom and Restitution Act have gone in favor of the companies and their personal religious beliefs. The only thing in this case left to talk about is the issue of whether or not judicial review is really good for this country, or if not, using examples from this case. Judicial review? That is when the judicial branch and the Supreme Court check over what the other branches do and decide whether or not it is constitutional. Whether or not it is in the best interest of the country is very debatable. In theory, yes, because it allows for government to have a check and keeps it from becoming too powerful and overextending with the powers that it does have. But it is not quite infallible, because nowadays the judges all have a political side on which they almost always vote on, so it often comes down to just one judge to make the final decision. But in this case, I believe that it was the best for the country, because it helped those who didn't want to be forced into doing things that they believed were morally wrong.